Hi there, I'm estate planning attorney and strategist Paul Rabelais, and I just realized that I've been an estate planning attorney for more than 28 years. Can you believe that? So, but it's true, and in those 28 years, I've seen a significant trend with an emphasis on clearly new concepts that are most important for people when they engage, a lawyer to get their legal affairs in order. So what the purpose of today's video is just to compare old school estate planning versus new school estate planning. The problem is some of that old school estate planning, which was really appropriate and popular 20 years ago, 30 years ago, 40 years ago, it's still going on out there, and it really shouldn't be for reasons we'll get into, and I hope to make obvious as I go through 8 different old school versus new school trends in estate planning legal services, plus I may throw in one bonus at the end. So let's get started. Trend number 1, old school versus new school, is old school, and look, let me just go ahead and disclaim or preface this. These are just trends. They don't apply to every single person's particular circumstances. So, but just trends that we see. So number 1, old school estate tax planning, new school Medicaid eligibility planning. Here's the deal. Estate tax planning used to be 20-something years ago, if you died, you add everything up that you have, or at least your survivors do, and if you add up the value of your home and everything else you own, your IRAs, your retirement accounts, if it was more than $600,000, there would be an up to 55% federal estate tax due to the IRS, plus here in Louisiana, we had a Louisiana inheritance tax. And families would get walloped by the estate tax. So obviously it was always a top priority when I set up my estate. I want my family to pay as little estate tax as possible, and that was oftentimes the number one concern that needed to be and was addressed in estate planning. Well, today the estate tax exemption is $11.4 million. It's not $600,000. Married couples, really, it's $22.8 million. So just about every family can leave whatever they want, however they want, and not have to worry about what is now a 40% estate tax. What people do worry about, though, because they're living longer and they're getting sick and they're needing long-term care, and that care is really expensive. Now the new trend is this Medicaid eligibility planning. If I need care, how can I protect the value of my home, and how can I protect my life savings? Oh, and how can I protect, property and other things that I have? I see a paper towel roll waving in the background, but hey, that's a bonus for you. I'm cooking on I'm green egg. I got a prime rib going on in there. I can't wait. All right, so that was trend number 1, old school estate tax planning, new school Medicaid eligibility planning. Trend number 2, old school, the irrevocable life insurance trust. New school, the irrevocable income only trust. Go back to the old school irrevocable life insurance trust. The concept was, oh my goodness, if I have more than $600,000 and I don't want my family to be burdened with a 55% tax, I'll create a trust, have the trust own some life insurance on my life. When I pass away, those life insurance proceeds won't be part of my estate, but they can be used to pay the estate tax burden. Well, none of that is relevant anymore. What is relevant is the new trend, irrevocable income only trust. Let me put my assets that I have in a trust, get them out of kind of my name for nursing home purposes and Medicaid eligibility purposes, but retain some element of control over those assets after I transfer them out of my name. That way I won't lose everything I've worked for, and my family won't lose our home after we pass away from the Medicaid rules. So that's trend number 2. Was old school irrevocable life insurance trust, new school irrevocable income only trust. Trend number 3, old school $15,000 annual exclusion gifts, new school, those are useless. So old school, oh, I have more than $600,000, let me give $15,000 to all of my kids, maybe even my grandkids, maybe even other people to get it out of my estate. And that way there won't be as much estate tax when I die. Today, since most married couples don't have 22.8 million and most single people don't have 11.4 million, those $15,000 annual exclusion gifts are useless. In fact, they create problems because the uninformed attempt to make these $15,000 gifts in an effort to get some assets out of the estate for Medicaid eligibility purposes. But that's useless because this 5-year penalty period doesn't start until you transfer everything out of your estate into perhaps one of these irrevocable income-only trusts that we talked about earlier. So these little piecemeal transfers, they do more harm than good. So that's number 3, the $15,000 annual exclusion gift. Old school, new school, trend number 4. Old school, married couple, first spouse dies, don't want any of the assets of the first spouse to die to be lumped into the estate of the surviving spouse to die. Don't do that, because that lumping of the first spouse's to die's estate into the second spouse's to die's estate causes the second spouse to die's estate to be unnecessarily large, and then another big estate tax hit when the surviving spouse passes away with all of the former marital assets. New trend. We want to, for tax purposes, lump everything into the surviving spouse's estate. So the family benefits from this double step up in basis for capital gains tax purposes. Here in Louisiana, as in all community property states, when the first spouse dies, all of the community property, not just the deceased spouse's half, gets a new stepped up basis in the event assets have appreciated since they were acquired. And then if for tax purposes all of the assets of the first spouse to die are lumped into the estate of the surviving spouse, then when the surviving spouse dies, all of the assets, not just the deceased, the surviving spouse's half, but all of the assets get another step up for capital gains tax purposes. And that allows all prior appreciation to go to the family untaxed, often overlooked. Nobody understands it, but nonetheless, it's a trend. Old school, don't lump anything into the surviving spouse's estate. New school, lump everything into the surviving spouse's estate to get the double step up in basis. All right, so here we are, we're on number 5. Number 5, old school, and I realize it doesn't apply to everybody. Old school was, let's make sure we cover what would happen if a child dies before me, and that was just a big part of the estate planning. Now the bigger part is, let's make sure we cover what happens if my child gets divorced. I don't want him to lose his inheritance. So, people are living longer, children are getting divorced and remarried at rapid rates. And so the emphasis is not so much on if my child dies before me, but if my child gets divorced, I don't want my daughter-in-law, son-in-law, ex-daughter-in-law, ex-son-in-law to control any of my money. Number 6, old school, do all this through your will. New school, do all this through your trust. So old school, it's just the way lawyers were trained in law school many, many years ago in their wills and donations class, where you do all of this through the will and you leave everything in your name, and then when you die, everything's frozen. And we all know the horror stories that people hear about lawyers cashing in on the probate and how difficult and expensive that can be. That's old school. New school, many people now wanting their family to forego entirely that government, court, attorney involved probate process when they die, so they set up their living trust, name family members as successor trustees to be able to settle everything when you pass away without having to go through any court or attorney involvement. Old school will planning, new school trust planning. Number 7, kind of a related one. Old school is probate. New school is trust settlement. So just like I said earlier, when you pass away and you have your home in your name and investments in your name, then all those things are frozen. Your family's kind of stuck. They got to come hire lawyers like myself who guide the family through a court process that many people perceive as expensive, time-consuming, and just an all-around pain in the you-know-what. So new school, have assets in your trust. Things in a trust don't get frozen. They don't have to go through the court system when you pass away. Maybe you appoint your adult child or children as the successor trustees. Perhaps they're even the beneficiaries of the trust when you pass away, and they can, right after you pass away, transfer assets out of your trust to themselves without going through a difficult process. Number 8, or number 7, I'm losing track. Probably number 8 here. Old school, all of your estate planning custom provisions were, all of that effort was put into putting those provisions in your will or trust. New school, emphasis needs to put on custom beneficiary designations. More and more people these days, the majority of their financial assets are in their retirement accounts, their 401ks while they're working, their IRAs after they retire. Their will or trust has nothing to do with where those assets go. And so a lot of effort often goes into creating the will, creating the trust, but the beneficiary designation stuff is often overlooked. So now custom beneficiary designations that are consistent with those custom will and trust provisions are part of the new school estate planning custom beneficiary designation provisions. And then the last one, number 9 on my list, is old school traditional family. Mom and dad had 3 kids, very simple. Mom and dad's goals are exactly the same. They want to stay in control. They want to leave it to the 3 children equally. They completely agree on who should handle things when they're incapacitated. New school, blended family. Again, people living longer. Traditional couples, one spouse dies or they get divorced, and then there's a remarriage situation. And in those remarriage situation, you're often dealing with a couple. Husband has his own children, wife has her own children, and so there's some conflicting interests there. And so the estate planning needs to be done to, yes, protect the surviving spouse the right way, but also protect the children of the first spouse to die. That's the blended family situation. And then the last bonus old school versus new school trend is, and this is really for the professionals, the layperson isn't going to understand this, but it has to do with some what can be to some, complicated estate tax reporting provisions. Old school, the Q-tip election. And we used that when the first spouse to die's estate exceeded the appropriate exemption amount, so that the estate of the first spouse to die would not have to pay any estate tax, and that tax would be sort of deferred until the surviving spouse passed away. Well, we don't see Q-tip elections anymore because of our big estate tax exemption. But the new trend is now towards portability, the portability election. So first spouse dies, first spouse doesn't have enough of an estate to require that an estate tax return be filed, but the surviving spouse wants to be able to use the first spouse to die's unused estate tax exemption. So then a portability election is made on the estate tax return, Form 706, of the first spouse to die when that's appropriate. Okay, so there you have it. Again, just trends. Nothing hard and fast for every particular situation, but in general, there's definitely a shift in what's most important. And I have this feeling, just as this observation, that a lot of people, a lot of lawyers, I'm a lawyer, a lot of professionals are kind of stuck in that old school estate planning, and they got kind of comfortable in it, and so they haven't really embraced the new school estate planning, which, quite frankly, what people tell me is far more important issues than the old school stuff. So hope that helps. What I'd like to see you do is subscribe to the channel, and that will somehow enable YouTube, maybe to enable you to see more of my videos. I've made hundreds of them. And then, of course, the thumbs up on the like button, if you could punch that, that'd be really fantastic. And then really take a minute, type in some comments below, because people read those. especially when they're positive and constructive. And your comments, your prior history, your examples, that helps everybody. That way, it's not all just coming from me. Then we've got other people commenting with their kind of unbiased comments about these particular subject matters. So anyway, I'm Paul Rabelais. I'm an estate planning attorney. Help people all around Louisiana get and keep their legal affairs in order. Hope all this helps. We'll see you next time.